So, very good evening, my dear friends. Welcome. And today we are going to discuss about the duties of directors and also the liabilities of directors. These are all the two topics we will finish off under the Companies Act 2013. Now, the duties of directors are concerned. The fiduciary duties point I have already discussed it elaborately. I have given you the case law, English as well as Supreme Court, so that there is no need to repeat. My earlier lectures already contain all this particular vital information. Now, friends, Section 166 of the Companies Act 2013 contains the necessary provisions on this particular subject of the duties of directors. And then this particular provision says under the subsections, subject to the provisions of this Act, a director of a company shall act in accordance with the articles of company. So the duties of the directors are basically stated in the articles of association. And then second, the section 166(2) deals with the fiduciary duties. A director of a company shall act in good faith. That's why fiduciary duties I said so. In order to promote the objects of the company for the benefit of its members as a whole and in the best interest of the company, its employees, shareholders, the community, and for the protection of environment. Please see, if a particular company is not run properly and the good company has become a bad company, then it is several hundreds and thousands of workmen with families will be on streets. If there are 100 workmen with at least minimum 5 members, 500 people will be on the streets. So that is where the concept of social justice comes into picture, and then interest of community, then protection of environment also come into picture thereon. For all these things, you have to study necessarily this particular provision under subsection 2 of section 166. Then friends, subsection 3 says, the director of a company shall exercise his duties with due and reasonable care and skill and diligence, and shall exercise independent judgment. Of course, directors will have to take ultimately collective responsibility. That is where lies with the board of directors. Then there is a don't. The director of the company shall not involve in a situation in which he may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. And then director shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, his partners or associates. And if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to the gain to the company. And he will be also liable to the particular persons who are victimized by this particular director's actions. Well, friends, the director further under subsection 6 cannot assign his office. This is not assignable, and any assignment is void. Then lastly, because I ultimately tell you it is the Indian Contract Act that binds the parties in this particular complexity of corporate entity. Then the last point, the director of a company, if contravenes the provisions of this section, he shall be punishable with fine which shall not be less than 1 lakh, but which may extend to 5 lakh rupees. That is a penal provision. So, the directors in general have got duties towards the company, and then they are answerable to the shareholders, and then they have got their own liability in the event they have not properly carried out their duties. And under the fiduciary duties, they should not make use of company funds, and they should not compete with the company's business. They should act in good faith, and they should not be negligent. They should not exceed their powers. These are all the common things which are provided under the duties of the company. The statutory duties are concerned. This is under section 168, and there are also certain duties under the taxation laws, and then under various laws like corporate laws, SEBI, SECRA, depositories, and then FEMA, All these legislations also will bind the directors of the company, the board of directors as a whole, and they are all called officers in default in the event a default takes place. So friends, with this background, we close our discussion on the duties of the directors. Then we will now go to the liability. What is the liability? In the event the directors commit any, violation of these particular duties, then the liability will follow. Liability will be sometimes imprisonment, sometimes fine, sometimes both. It all depends upon the situation thereon. So you have to see the company directors will have liabilities towards outsiders, towards the company, towards the shareholders, and liability for statutory defaults and violation. In this particular segment, you are supposed to study this particular subject matter. Then the first part is that outsiders, how directors are liable to the outsiders thereon. This is the most important aspect, my dear friends. In this case, the directors are personally liable to the outsiders when they enter into contracts on behalf of the company and if the contract turns ultra virus. And if the directors, act outside the scope of the company, and then if they act in their own name and not for and on behalf of the company, without disclosing that and they have acted on behalf of the company but for their personal benefit, then they are liable to the outsiders personally. And then when the company is a contracting party, and then director should state that he is doing so for and on behalf of the company. And if the director acts beyond the powers or he misrepresents, then he would be personally liable. Like in government also, every officer, whoever signs a contract authorized will have to do it for and on behalf of the governor or the president of India, as the case may be. That is called government contracts. Here, it is the company contracts. The directors have to sign for and on behalf of the company only. It has to be entered into the name of the company and not in the name of the directors of the company. Then friends, the next important thing I have already explained, section 26, that when the directors issue a prospectus and then violation of provisions of the Companies Act, SEBI disclosure and investor protection guidelines, and then various other corporate laws, I have already explained that particular aspect to you. Then if they are found guilty of fraud, then the shares are in irregular name, then they are liable under various provisions of the Companies Act. And friends, of course, prior notice has to be issued to them and an explanation will have to be called for. Now the second point, what is the liability of the directors to the company for their particular activities? Well friends, this particular liabilities are concerned. In fact, the directors' negligence in performance of their duties, and in that event the company suffers a loss, then the directors will be liable for making good that loss to the corporate entity. And then the appropriate standard of skills and then the acumen depend upon the circumstances of each case as it is required. So friends, there is one important case, City Equitable Fire Insurance Company Limited, City Equitable Fire Insurance Company Limited, 1925, Chancery Division, page 407, where it was held that it is not negligence for a director to fail to attend, suppose, a board meeting and thereafter not ascertain the proceedings thereof. Also, where the directors delegated their power to manage the company to a properly appointed MD who was able to dispose of company's investments for his own requirement, then it did not amount to negligence. What is important, he is committing an act which is ultra virus. Their powers are ultra virus, the powers of the company. And when any illegal act or breach of trust is committed, and liability when guarantee for company's debts is given. These are all the things which come into picture. The directors, if stand as guarantors, then they are liable personally. Bank of Scotland versus Wright. Bank of Scotland versus Wright, Queen's Bench decision, 1992. In this case, a director guaranteed his company's debts, and his company became liable as a guarantor of subsidiary company's debts. Then the director's guarantee would cover those debts also, and directors are held personally liable. This is Bank of Scotland versus Wright. And then, friends, there is one more important case in this regard, that is Bank of Baroda versus F.C.S Liquidator, 1992, 73 company cases, 688, Madhya Pradesh High Court. In this case, certain directors who had guaranteed the company's debts retired, and then the new directors were appointed, and they also signed the guarantee bond afresh. Now the question, who is liable, old or new? All the directors, including old directors, are held to be liable jointly and severally, as there was no agreement to show that the earlier guarantee had ceased to be operative, so both old and new directors are held liable. I hope now you understand the importance and impact of this particular subject matter. Then, next is Indian Overseas Bank versus A.B. Senan, 1999-96, company cases, 839 page, Kerala High Court. A bank granted a temporary overdraft facility to a corporate entity and accommodation for the purpose of meeting working capital requirements. And then the advance was granted on the strength of a specific undertaking and a promise made by the respondents, who were the managing director and additional director of the company. And then they promised it to liquidate within a month the cumulative outstanding amounts, including costs and expenses. Then a decree was passed against all of them, and then the courts held it is justified, and then the decree is valid and it is executable against directors also personally. Now, in the same way, I am talking of the second point is liability of the directors against the company. Liability to the company. Then the liability in respect of company's debts, how far the directors are personally liable. In fact, there is no specific mention, but however, to fix a director, the principles of agency should be applied. And then in the transaction, Kundan Singh versus Mega Transport Company Limited, 1987-62, company cases, page 600, Punjab and Haryana High Court. Then, friends, directors are liable for any misapplication of money to any ultra-virus purpose. Ultra-virus Act, already I told you, is void. So this is Kathiawar Trading Company Limited versus Veerchand Deepchand, 1893, ILR 18, Bombay High Court, page 19. So, friends, now one more important aspect is that whether a shareholder can maintain an action against the directors. So, in this Jahangir Rustimji Modi versus Shamji Lodha, 1867, 4, Bombay High Court, OC 185. In this particular case, it was held that a shareholder can maintain an action against the directors to compel them to restore the funds of the company employed in an ultra-virus transaction. Directors have got a very heavy liability here, and the courts are virtually merciless. There is one more judgment, Reford Benefit Building and Investment Society versus Offered Benefit Building and Investment Society case, 1886-35, Chancery Division 502. In this case, the directors are personally liable if they act beyond the powers delegated to them, even though the acts are not ultra-virus of the company. It may be ultra-virus their powers, but not ultra-virus the company. Then, one more important citation. if the company, whether there is a liability of directors for personal profits being made to them. Diversion of the company's clientele to a business carried on by the director or himself is in fact taken as a issue of liability. Cook versus Deeks, 1916, 1 appeal case 554, then 564. Then AIR 1916 PC 161. And then one more thing is that in another English case, that is Cramley Precision Engineering Limited versus Brion 1964, All England Reports 289. A director of a company was held liable when a director patented and exploited in his own name an invention made during the course of employment with the company, because the patent should go in the name of the company, and naturally in this case the director tried to make a personal profit and he was held liable and responsible. Now friends, liability to outsiders we have seen, liability to company we have seen. Third point is liability to shareholders. That is called trusteeship. That's what I told you again, the liability if service fiduciary duties come into picture. Here, if the shareholders suffer any loss due to the negligence of the directors, they are personally liable for the loss, but it is the company in majority in general meeting can make a decision, First versus Harbottle. I have already sent in advance that particular judgment to all of you. So, when the directors have acted malefied or beyond the powers, the majority of the shareholders must in such a case be in fact held entitled to take steps to redress the wrong. Dr. Sacha Charan versus Rameshwar Prasad Bajoria, 1950-20 company cases, pages 39 and 48, All India Reporter, 1950, FC 133. Even a single shareholder then can prosecute the particular proceedings, and then he can move the court of law, and then he can take appropriate action. Now friends, the last part of our discussion today, that the liability for statutory defaults and violations. So I have already explained, but I give you a briefing again. One is prospectus. In contravention of section 26, I have already given a very detailed explanation for section 26. Apart from section 39 also, the directors are jointly and severally liable to repay the, in fact, share application money. I told you this particular aspect also in the event minimum subscription is not procured. So, prospectus, minimum subscription. Then further, the officer in default. The directors are, they happen to be the officers in default. Then friends, another important thing, the securities have to be in fact put on the stock exchanges, section 40, and failing which the directors will be held personally liable. In the same way, directors have to disclose their interest. I have dealt with that subject yesterday. And then the liability under various corporate laws like the Income Tax Act, the rules thereon, the sales tax, the GST, and then the Central Exchange and Salt. Now the GST has come, then Customs, FEMA, the NI, the PF, ESI, and under various legislations, the particular directors would be held personally liable, and then for default, they would be subject to imprisonment as well as fine. Apart from that, the liability would be a common law liability, a liability would be a Companies Act under IPC and other legislations. And these multifold, all these provisions will have to be taken care of. Then the liability, the directors are taken as the officers in default. And under those circumstances, being the officers in default, they will be held liable. And apart from the company being fined, the directors also would be fined, directors also would be subject to imprisonment. So friends, first duties. Duties fail, liability will come. In the point of liability, outsiders, company, shareholders, and statutory liability. All these factors will come into picture. And the liability could be criminal as well as civil. Under criminal, the Companies Act, the Income Tax Act, various other corporate legislations will come into picture. Accordingly, you have to give your appropriate answer. So friends, with this background, we conclude our discussion on this particular subject matter and we will meet again. Thank you very much. Good night.